And welcome to our next session, The Search for Justice. Our distinguished panel will examine the content and significance of the hundreds of legal procedures that were initiated against the perpetrators of the Holocaust, from the high-profile Nuremberg trials, which took months to prepare and involve thousands of individuals, to local, often immediate events condemning collaborators, to the Soviet trials of Jewish leadership of the ghettos. Please welcome Mark Edele of the University of Melbourne, who will serve as moderator and introduce the panel.
Thank you, Michael, and good morning from Melbourne. It's 7:30 a.m. here, so I have not made it to my office. So if you hear noises in the background, it's my daughter going to school without the usual help of her father to put on her uniform or something. I will serve as your MC and moderator. I'm Mark Edele from the University of Melbourne. I'm the Hansen Professor in History at this institution. I'm a historian of the Soviet Union. I will introduce each speaker in turn. We have 3 speakers and 3 papers, Diana Dumitru, Joshua Rubenstein, and Francine Hirsch. I will introduce each of the speakers just before they speak. They will then speak for 15 minutes each, after which we'll have a conversation between the speakers, followed by a Q&A. The Q&A will be moderated by me via the chat. So if you have a question, please put it in the chat function, which you will see on your screen. Okay, our first speaker is Diana Dumitru, who is an associate professor at Creangă State University in Moldova. She is the author of 2 books. The first one in a language I do not read, but Google Translate told me that it's called The Holocaust, Texts, Theories, and Memoirs, was published in 2009. And more recently, her second book, The State, Anti-Semitism and Collaboration in the Holocaust, The Borderlands of Romania and the Soviet Union, came out with Cambridge University Press in 2016. She has also authored over 40 peer-reviewed articles on Holocaust, anti-Semitism in the USSR, late Stalinism, and the post-war trials. She's held a variety of research fellowships and is currently working not on 1, but as you do, 2 books. One is a co-authored volume with the working title, The Trial That Shook the World, the Slansky Process and the Dynamics of Czechoslovak Stalinism. And the second one is a single-authored volume with the title, From Friends to Enemies, the Soviet State and its Jewry in the Aftermath of the Holocaust. Today, she will speak on the Gordian Knot of Justice, prosecuting Jewish survivors in Stalinist courts for collaboration with the enemy. Diana, please.
Thank you, Mark, for this very generous introduction. And good evening to everybody, because here really evening is like 10:35 now. And hopefully I can share my slides with you and you can see on the screen. So it's a great pleasure and honor to speak together at this conference nearby many distinguished colleagues and dear friends. So since the time is really short, I'll go straight into my topic. And I'll say just a couple of words. I will start immediately with maybe my sources so that you understand what my project is based on. So this particular presentation and this research project is based on a collection of, one may say that not too many documents, but I'll be talking about 11 dossiers of Jews who were accused of collaboration with Romanian authorities. And these 11 dossiers, they represent just a tiny fraction of a bigger collection of over 300 dossiers from KGB archives in Moldova. And since it's kind of impossible to see them in Chisinau, the shortest way to study these files is at the United States Holocaust Memorial Museum, where I saw them in copies. So all these trials took place in 1944, 1948, and they were judged by military tribunals. So hopefully the slide is working, and maybe just like a couple of words for those who know a little bit less about the Holocaust in this particular area of Eastern Europe. So all defendants, all 11 defendants that were put on trial had some leadership roles in the administration of Transnistria. So this is the territory. And this territory, it's a historically Soviet territory, but where the Romanians in 1941 deported a huge number of Bessarabian Jews, of Jews from Bukovina, and they also imprisoned local Jews. So you have in local ghettos and camps of Transnistria mingled together, imprisoned together, so-called like Soviet Jews, or you call them Ukrainian Jews. They refer to themselves in different ways. And you have so-called Romanian Jews that sometimes are called Bessarabian Jews, Bukovinian Jews. So I'll be talking about this like Romanian versus like Soviet Jews. So the typical defendant profile was as it follows. So from 11 of them, 10 were from Bessarabia and 1 was from Romania proper, like the part, Romania. And all of them had secondary education or professional education, which made them much more educated than the rest of the prisoners inside the camp. Of course, all men, most of them in their 40s. All of them spoke Romanian in addition to Yiddish. So why all these people from Bessarabia? And the response is that really when the Romanians were selecting Jewish ghetto leaders, they were trying to select people whom, and of course, Soviet Jews were out of questions because they were suspicious that maybe they have sympathies towards communism. Even more, they assumed that the Jews who are better off, they're probably also less prone to communism. So correspondingly, you have this profile of the defendants being from a wealthier background. And of course, like all of them who were socialized in the interwar era in the Romanian state. One of the witnesses in one of these like dossiers tried to summarize for the interrogators like who were the leadership and why they were chosen and how. So this is what the person said. So the leaders, they were selected by the Romanian gendarmerie from the people loyal to the Romanian administration. All these people employed special privileges. They and their relatives were not sent to work. They were offered unlimited rights. They did whatever they wanted to the Jews residing in the ghetto camp. And only Jews brought from Romania and from the right bank of the Dniester, meaning Bessarabia, were appointed to work in the town hall in the positions of mayor or brigadiers. They were so-called honorable people, former merchants and rich folks. And in the, I'll just like summarize the most important accusations that we can see in these like files. Some of them quite big files, like for example, they ran from like 150 pages to one file had around like 600 pages. So a very common accusation that it's present in many other East European camps is about bribe taking, protecting wealthy Jews. Then also a particular accusation was about refusing distribution of material aid to Soviet Jews, preparing lists of dangerous prisoners, and these prisoners later were shot by Romanian authorities, distributing prisoners to dangerous work, and especially if prisoners were sent to the area controlled by the Germans, it was quite frequent that those prisoners would never come back because they would be killed after they were finished their work project. And another specific accusation was refusing registration inside the camp for the Ukrainian Soviet Jews and Bessarabian Jews, although they had to be registered by default. And then betrayal of fugitive Jewish individual to Romanian authorities. Actually, from this like body of different accusations is that you do see that Soviet Jews somehow suffered discrimination as a group at the hand of the ghetto leaders. And you do have a number of testimonies of Jews who survived the camp, because many were around, like we're talking about like 1,000 being around and being able to testify in 44, 45, 46. And they say clearly that they were the first one to be sent to dangerous work assignment. They were the last one to be provided any kind of material help. And actually, inside the pyramid of the groups of Jewry inside the camp, you do see the following hierarchical structure. At the bottom were Soviet Jews, especially those who had any kind of connections with the previous regimes. If they were military, if they were teachers who worked in various Soviet institutions, they were at the bottom of that pyramid. Then the Bessarabian poor Jews were in the middle, and then wealthy, highly educated Jews from Romania were at the top. And although one might be inclined that it's something that transpires in Soviet documents because this is how they would like to present things, actually these findings really align nicely with the findings of especially Israeli scholars who worked just with testimonies of Jewish survivors from Transnistria, who after World War II emigrated to the West and who gave a lot of testimonies afterwards. And the findings of Dalia Ofer, Sarah Rose, and Gali Tibon also confirm the same thing, that yes, indeed, in Transnistria, the local Jews were the ones first to be assigned to forced labor and the last one to receive any kind of help. Then a really interesting point that I wanted to bring into discussion here is that inside these dossiers, in the minutes of the interrogations and also in the appeals that the defendants said, you do see a clash between the defendants and between the Soviet justice represented either by interrogators, prosecutors, judges. And frequently we read the Soviet interrogators' questions about like, why did asking, wasn't it like in your power to help somebody, to register, for example, a person inside the camp, and instead you didn't do this, and so the person was executed. Or, for example, they would press the former Jewish leaderships like, why didn't you pay a bribe to authorities? Because we do know that they're all bribe taking. And the Jewish ghetto leaders would push back, and they will try to defend themselves. And for example, the minutes would include the full kind of defense line of one defendant said, for example, in that scary time of despotism and violence from the side of the authorities, there was no possibility to do something without risking the life of the entire camp, which I had no right to do. And then in another case, another former ghetto leader who handed over a Jewish fugitive to Romanian gendarmerie, and the person was killed. Again, he was interrogated, and the interrogator asked, like, why didn't you help the fugitive? And he said, I was afraid. So the interrogator is asking, is pushing. So because you're a coward, you just let him die. And the defendant saying, like, it's not me who shot him. And if you really want to judge me and see how I did, pay attention to the fact that at the beginning, I had in my camp 700 people. And by the end, by the liberation, I had 1,200 people. So if I was a bad leader and if I was like damaging the population from the camp, for sure, they would have tried to flee, not to come to my camp, to stay in this camp and to wait for the liberation. So what's interesting for me is that some of these arguments, I do see them in the argumentation of the Supreme Court. When they return some cases for investigations, and we do have such cases when Moscow for 3 times returns a file to Chisinau and say, start from scratch. They do use the arguments of these Jews. So an important discovery is something that relates to Soviet Moldavia and the specificity of pre-war legacy. It's very interesting to see that defendants' legal appeals were very well written, with coherent arguments, and really with an impact. So interestingly, I think a role was played by Jewish lawyers in Soviet Moldavia. And in 1946, we have 59 of lawyers from Soviet Moldavia. They were of Jewish ethnicity. And even judging by the names of the lawyers involved, Dain, Furs, it looks like they were Jewish. So they were very good. Most of them were trained outside, of course, outside Soviet Union. They were trained in France, Hungary, interwar Romania, and they had a different style of work. They were arguing based on technicalities, asked for amnesty, and they were really working hard for their clients. In one striking case, they convinced a courtroom guard to sign a testimony that the minutes of the court's hearing omitted important testimony, which is unheard of. And then they advised to the defendants to bring collective letters of support, individual letters of support. So they had like very sophisticated work was done. Punishment. As you can see from this table that I put together, the big majority of this, like reduced sample, the majority of them received like 10 years imprisonment sentence. And of course, this is like a severe punishment, but I want to remind those who maybe don't know so much about the judiciary system. There was the minimum allowed by the penal code for the article 54/1. Judged were put on trial under this article. So I would say that the court showed restraint in the cases of these Jewish survivors, and I'd say probably because they were aware of the complexity of their situation. I want also just to make one like small last point that Seth Bernstein and Irina Makhalova, they studied the collaboration in Ukraine based on a collection of 956 cases. And they calculated that the court conviction of people accused of collaboration in Ukraine was 16.7 years. Well, the people from my selection, they had an average sentence of 10.5 years. Also, Seth Bernstein and Irina Makhalova showed, for example, that the average sentence for Germans, ethnic Germans in Ukraine, was over 21 years prison sentence. Also, in the case of death sentence, Bernstein and Makhalova demonstrated that a death sentence was at the 21%. In my case, the death sentence was this one case reaches 9%. And yeah, it's conclusion time. So I want to say that the Soviet court and judicial institutions became a locus of heated moral and legal debates about the boundaries when acting and the ghetto leaders, when they had to decide and prioritize of the ghetto population, they chose to help especially those neighbors who were culturally or socially closer to themselves. And we do recognize there was an uneven fight between the Jewish ghetto leaders and Soviet justice system, but at the same time, each of these sides adversaries and supporters, and they were fighting it. And then the argument used to support defense of Jewish leaders they, in a way, both challenged and expanded the Soviet officials' rigid view of collaboration. And this is visible in the internal documentation. The last point that I just finished emphasizing is that compared to the finding about other ethnic groups, the punishment of Jewish defendants somehow seemed to be on the lighter part of the spectrum. Thank you very much for your. I'll stop sharing my screen here.
Thank you very much, Dana, for this wonderful paper and your great time discipline. You were exactly on time. If this were a in-person conference, there would now be applause. You just have to imagine that. Our second speaker today is Josh Rubenstein, who is a distinguished. Oh, I just had something weird happen. Sorry. Our second speaker is Josh Rubenstein, who is a distinguished independent scholar. In fact, I was not aware, Josh, that you did not hold an academic appointment, and I was somewhat surprised by this. Josh has achieved his very influential work while he worked as Northeast Regional Director of Amnesty International USA from 75 to 20. He was also an associate of the Davis Center at Harvard, which is one of the world's leading centers for the study of Eurasia. That means the former Soviet Union. In 2015, Josh became the Associate Director for Major Gifts at Harvard Law School. He's the author of several highly regarded books, and in particular to highlight here is Stalin's Secret Pogrom, the Post-War Inquisition of the Jewish Anti-Fascist Committee, which came out with Yale UP in 2005, and the partial translation of the incredibly important source, The Unknown Black Book, The Holocaust in the German-Occupied Soviet Territories, which came out with Indiana University Press in 2010. Most recently, Josh has published Days of Stalin, which came out with Yale UP in 2016 and as paperback in 2017, which students at the University of Melbourne read to find out if what they saw in the death of Stalin has any relationship to what actually happened. Today, however, Josh will speak on the trial of the Einsatzgruppen at Nuremberg, as well as some other remarks on precursor trials by the Soviets in Creangă and Kharkiv. Josh, please.
Thank you very much. Our colleague Maxim Schreier spoke about the trials in Krasnodar and Kharkiv yesterday. And they were very important. They took place in 1943 while the war was still going on. And the principal message was to stop collaboration by civilians. But I think that today I'll focus my remarks on the Einsatzgruppen trial. This was not a trial that the Allies expected to hold. Telford Taylor, who was one of the leading prosecutors for the American side, expected to hold as many as 18 trials following the International Military Tribunal. This would involve bankers, would involve doctors, and a whole different categories of people within the German and Nazi bureaucracy of death. But Telford Taylor had a very important colleague in Berlin, a young man named Benjamin Ferenz. Ferenz was a Hungarian refugee to New York who attended City College of New York and then Harvard Law School. He graduated Harvard Law School in 1943 at the age of 23. Let me point out, Ben Ferenz was born in March of 1920. He is still around, bless his heart, at the age of 101. So while he was in Berlin working with Telford Taylor, he was unexpectedly presented with a whole group of documents, the reports from the Einsatzgruppen mobile shooting units to authorities in Berlin detailing their actions. So Ben immediately understood what this was. he sat down with the reports and he used an adding machine. And as he read each page, he added up the victims. As he told me in an interview, he stopped when he reached 1 million. So he went to Telford Taylor with these documents and said, look, we've got to bring these guys to justice. We've got to bring the commanders of these Einsatzgruppen leaders, Einsatzgruppen mobile shooting squads, to justice. And Telford Taylor didn't know what to say. They were already planning so many other trials. The budget was tight. Did they have personnel? But he challenged Ben Ferenz. If you think you have the time and energy, you can take this on. So Ben Ferenz decided he would do that. And the trial opened at the end of September 1947. We have just a couple of minutes of a clip from his opening statement at the trial, and I'd like our technical support team to show that very brief clip now, please.
Bear with us as the clip begins.
Here we are.
And you will ascertain if the defendants are present. May it please your honor, the defendants Otto Rausch and Edward Strout are absent. To go. Otto Rausch and Edward Strout have been arraigned separately because on the opening day they were too ill to respond. So that the record will show that they now have been arraigned properly and in accordance with law. We are now ready to hear the presentation by the prosecution.
This was the tragic fulfillment of a program of intolerance and arrogance. Vengeance is not our goal, nor do we seek merely a just retribution. We ask this court to affirm by international penal action man's right to live in peace and dignity, regardless of his race or creed. The case we present is a plea of humanity to law. We shall establish, beyond the realm of doubt, facts which, before the dark decade of the Third Reich, would have seemed incredible. Courts will show that the slaughter committed by these defendants was dictated not by military necessity, but by that supreme perversion of thought, the Nazi theory of the master race. We shall show that these deeds of men in uniform were the methodical execution of long-range plans to destroy ethnic, national, political, and religious groups which stood condemned in the Nazi mind. Genocide, the extermination of whole categories of human beings, was a foremost instrument of the Nazi doctrine. Mr. Glancy will now read part one of the opening statement.
On 22 June 1941, with no previous warning, Germany invaded Soviet Russia. The Einsatzgruppen, already alerted, fell in behind the marching columns of the Wehrmacht as an integral part of the machine constructed for swift and total war. Within a space of 3 days, the training grounds in Saxony were empty, and all Einsatzgruppen had entered upon the performance of their various missions. Another form of extermination employed was asphyxiation by lethal gases in enclosed trucks or vans. Here again, the victims were induced to enter these death machines by the promise that they would be transported to other areas for resettlement. As the van left the loading area, it was filled with deadly fumes. A few minutes later, when the van reached the disposal point, the corpses were unloaded into prepared excavations, which became unmarked mass graves.
I think it's important to point out for our conference that Ben Ferenz, after finishing Harvard Law School, joined the Army. He was in Patton's Army and earned 5 battle stars. The trial at which he prosecuted was his first trial. He had graduated law school 4 years before, went in the Army, and had no other experience in court. The prosecution lasted for 2 days, only 2 days. It was totally based on the documents of the Einsatzgruppen reports themselves. And then the defendants had several months to defend themselves. And I'd like to just read a couple of brief paragraphs from my introduction to the Unknown Black book, where I discuss this trial. Faced with overwhelming evidence of their guilt, several defendants tried to mitigate their culpability by assuring the court that they did all they could to avoid gratuitous violence. Heinz Schubert, who was a direct descendant of the composer Franz Schubert, sought to establish his humanitarian credentials by explaining that he, quote, took care that the condemned persons were not beaten while being loaded into gas vans. And Ernst Bieberstein, who also oversaw the use of gas vans, assured the judges that he himself, and I'm quoting, saw the unloading of the dead bodies, that their faces were in no way distorted, and that death came to these people without any outward signs of spasms. And Otto Ollendorf, one of the famous defendants, claimed, it was my wish that these executions be carried out in a manner and fashion which was military and suitably humane under the circumstances. This is the kind of moral depravity that these defendants exhibited during the trials themselves. Ollendorf went on to say that he never permitted shooting by individuals in his Group D of the Einsatzgruppen, but ordered that several of the men should shoot at the same time in order to avoid direct personal responsibility. So they were more concerned about the psychological impact on the murderers than on the suffering inflicted on the victims. This trial resulted in death sentences for 14 of the 23 defendants. More defendants were sentenced to death at this trial for the murder of Soviet Jews than at any other trial at Nuremberg. But in spite of that, by 1948, there was tremendous pressure in Germany not to carry out the executions. The Americans now had a new opponent, the Soviet Union, engaged in a new war, the Cold War. And so they're very, very sensitive to public opinion in Germany. There were widespread petitions circulated in Germany to spare the defendants. At the same time, the High Commissioner for Germany, Lucius Clay, the famous general, retired back to America and was replaced by John J. McCloy, who had been Undersecretary of War during part of World War II. He felt very uncomfortable about carrying out the executions. So he called a judge from New York, David Peck, to set up a commission to review the sentences. Peck did not read the trial transcript. He did not interview Ben Ferenz, who was still in Germany, and offered to meet with him. And David Peck then issued a series of clemency suggestions for at least some of the defendants. In the end, incredibly, and I speak as someone who's in principle opposed to the death penalty, of the 14 men sentenced to death, only 4 were executed in May of 1951. They were Otto Ollendorf, who led Group D of the Einsatzgruppen, responsible for 90,000 deaths in southern Ukraine and Crimea. Paul Blobel, who had helped supervise the massacre at Babi Yar, Werner Braun, and Erich Neumann. All the other defendants, whether they had been sentenced to death initially, to life in prison, to 20 years, to 15 years, by the summer of 1958, all were released. The Americans, the Allies, suffered from complete moral exhaustion from handling these cases. And by 1958, less than 15 years after the defeat of Nazi Germany, they suffered from moral amnesia as well. When the New York Times reported on the release of the final defendants from this trial, the very short article in the New York Times commented that they had been held responsible for the murder, and I'm quoting, for the murder of hundreds of victims. They had been convicted for the murder of over 1 million victims. It was the second trial to use the word genocide in the indictment. We now know, as it's been discussed yesterday and today, that the Einsatzgruppen were responsible for the deaths of over 2.5 million Jews in German-occupied Soviet territory. And the New York Times shamefully commented that these men had been responsible for the deaths of hundreds of victims, and they couldn't even say that the victims were Jews. They simply said hundreds of innocent victims. So this was a very unusual trial. The legacy of the trial is very unusual. We're blessed by the fact that Ben Ferenz is still around to talk about his experience, and as we all know, works very tirelessly against the issue of war itself still to this day. But I think the legacy in the Einsatzgruppen trial points out how long it took to fully grasp what happened in German-occupied Soviet territory. So much of our conference this week, these days, the work of Julie Shervinsky's group, the end of the Cold War, access to archives, is what made it possible for us to fill in so many of the gaps about the history of the Holocaust in German-occupied Soviet territory. But we should not forget there was a very serious attempt at Nuremberg to come to terms with this aspect of the tragedy. And so I'm grateful to the organizers for inviting me, and I feel glad to be part of this panel. Thank you.
Thank you, Josh, for this very powerful paper. And stay with Nuremberg in our next paper. Our next speaker is Francine Hirsch, who is the Vilas Distinguished Achievement Professor of History at the University of Wisconsin-Madison. Francine made her name among historians of the Soviet Union with her first book, which grew out of her Princeton PhD, which was entitled Nations, Ethnographic Knowledge and the Making of the Soviet Union, which was published with Cornell University Press in 2005 and is mandatory reading at Soviet history courses all around the world. Her second book, which just came out last year, is Soviet Judgment at Nuremberg, A New History of the International Military Tribunal After World War II, which was published, as I said, in 2020 by Oxford University. And her new project, which is destined to win many prizes as her first two books, is on the entanglements between Russia and the United States in the fields of economics, science, and international law. But today she will return to Nuremberg and speak on the search for justice at Nuremberg, the Soviet contribution to the record of the Holocaust. Francine, please.
Thank you. Thank you for that lovely introduction. And wow, just based on the Joshua and Diane talks out, there's already so much I want to talk about as a group. So I'll start today. So what I'll be talking about is the Soviet role in bearing witness at the Nuremberg trials. There are some slides, so if it's easy to get those up and show them, fantastic. Oh, there we go. Wonderful. Thank you. So I published a book last year, Soviet Judgment at Nuremberg, which presents a new history of the International Military Tribunal, or IMT. This, of course, was the first of the Nuremberg trials, which took place from November 1945 to October 1946 at the Palace of Justice in occupied Germany. The United States, Great Britain, France, and the Soviet Union, the four major Allied powers, tried 22 former Nazi leaders, and we can go to the next slide, including Hermann Goering, Rudolf Hess, and Joachim von Ribbentrop for conspiracy, crimes against peace, war crimes, and crimes against humanity. They also tried 6 organizations, including the SS and the Gestapo. And this would turn out to be the only of the 4-power Nuremberg trials. So in part because of this, because the other Nuremberg trials were carried out by the United States alone, and for other reasons as well, Nuremberg is typically remembered in the US especially as an American story, with very little attention to the contribution of the Soviet Union. And so what my book does is it uses evidence from the Moscow archives, 5 Moscow archives, to bring the Soviets fully into the picture. It shows the tremendous Soviet contribution to the trials, as well as the many ways in which Soviet participation threatened to undermine the IMT's legitimacy. And it also uses the Soviet experience to tell a richer story of the Nuremberg trials as a whole. We see that Nuremberg was not just a struggle between the prosecution and the defense, but it was also a contest among the 4 countries of the prosecution, countries with very different ideas about justice. A struggle for power and for influence and for control over the narrative of the war. So in my comments today, I want to focus in on 2 individuals, on 2 Jewish men who played critical and very different roles for the Soviet delegation at the Nuremberg trials. And next slide, please. The first was the Soviet Jewish lawyer, Aaron Trainin from Moscow's Institute of Law. And so Trainin, just a little brief intro, he was born in 1883 in the town of Vitebsk in the Pale of Settlement. He received a law degree at Moscow University in 1909. He never joined the Communist Party, but after 1917, he very ably served the new Soviet government, and he developed an expertise in international law. And during World War II, Trainin played a critical role in shaping the international conversation about Nazi war crimes and in shaping the IMT's legal framework. The second person I want to talk about is Avraham Sutzkever, the Yiddish poet, a witness, survivor, and a partisan, whose testimony was absolutely critical for the Soviet prosecution at Nuremberg. And I'll talk more about Sutzkever's biography soon, but first I want to turn to Trainin and to one of my key arguments, which is without the Soviet push for an international tribunal and without Soviet ideas about international criminal law, the Nuremberg trials likely would not have happened. The creation of the IMT is often portrayed as a triumph of purely liberal, Western ideas about justice and the law. But it was actually the Soviets who were out in front during the darkest days of the war, pushing for a special international tribunal, as they called it, to try Nazi leaders. They were prompted by the brutality of the Nazi occupation and by the idea of reparations, and also by the desire for a public reckoning. The Americans and the British were initially quite slow to come on board. The Soviets created their own War Crimes Commission, the Extraordinary State Commission, that gathered and publicized evidence of Nazi atrocities, and Aaron Trainin put forward critical arguments about the criminal responsibility of Nazi leaders, which the Soviets published in a book called The Criminal Responsibility of the Hitlerites. Trainin argued that Nazi leaders could and should be tried for participating in a criminal conspiracy. He also argued that the planning and waging of wars of aggression, wars of conquest, should be punished as crimes against peace. And Trainin coined that term, crimes against peace. Trainin's book made its way across Europe to London and then to the United States, where it ultimately landed at the White House. Now, Trainin, to be clear, he was not the only lawyer arguing for the criminality of aggressive war, but whereas many European and American lawyers expressed unease about ex post facto or retroactive law, the Soviets had no such reservations. After the victory, and the next slide, please. After the victory, when the other Allied powers came around to the idea of an international tribunal, Trainin was one of 2 representatives that the Soviets sent to London to negotiate the Nuremberg Charter. And crimes against peace was one of the 3 categories of crimes set out in the Charter's Article 6, along with war crimes and crimes against humanity. A 4th charge, conspiracy, was later added to the indictment. Now, the Soviets, of course, had their own ideas about what an international tribunal should look like. And they had their own ideas also about justice. The Soviet Union had lost some 27 million people in the war. Their country had been devastated by the Nazi occupation. They took Nazi guilt as an absolute given, and they were expecting guilty verdicts and hangings down the line. They saw an international trial as an opportunity to demonstrate Nazi guilt and to tell a story about Soviet suffering and Soviet heroism. Soviet expectations and aims shaped their choice of personnel for the IMT. Almost all members of the Soviet legal team, next slide please, including Soviet Chief Prosecutor Roman Rudenko and the Soviet judge Yona Nikitchenko, were connected to the Soviet show trials of the 1930s. Next slide please. And Stalin appointed Andrei Vyshinsky, who had prosecuted the Moscow trials of 1938, 6 to 1938, also the big major show trials, to head one of the Soviet Union's 2 secret Nuremberg commissions. Stalin thought that the victors would control the script at Nuremberg, just as the prosecution had done in Soviet show trials and in the Soviet Union's own war crimes trials, like the Kharkov trial of December 1943. But Nuremberg was a 4-power trial. The Soviets were not running the show, and the defendants, much to the dismay of the Soviets, were allowed a very robust defense. Suffice to say, things did not go in Nuremberg as Stalin had hoped and planned. Now, that's all well and good, and Nuremberg had its ups and downs for the Soviets. But the Soviets, who had primary responsibility for presenting on Nazi war crimes and crimes against humanity in occupied Eastern Europe and the Soviet Union, they nonetheless made a critical contribution to the record of the Holocaust. This Soviet contribution is often overlooked, the same way that the Soviet contribution to the framing of the trials is often overlooked. And this is often overlooked in part because earlier Soviet war crimes trials, like the Kharkov trial, like Krasnodar, spoke of crimes against peaceful Soviet citizens, even when the victims were Jews. But in fact, from early in the war, the Soviets were publicizing evidence of the Nazi campaign to wipe out Europe's Jews. They did so through the Extraordinary State Commission and through the Jewish Anti-Fascist Committee and through other channels as well, including Aaron Trayanin's book, The Criminal Responsibility of the Hitlerites. The book's most important contribution was the idea of crimes against peace. But Trayanin also wrote about Hitler's efforts to annihilate the Jews. He described Hitler's atrocities against the Jewish population in the occupied Soviet Union, and I'm quoting him here, as part of a system of total extermination, applied on a scale inconceivable to the human mind. And Trayanin put the final solution into historical context, and that's what the Soviets called it at the time as well, writing that the Jewish people, during their many thousands of years of existence, have been more than once subjected to persecutions, but the Hitler atrocities surpass anything known to history. Trayanin understood on a very personal level what the Nazi invasion had meant for the Soviet Union's Jews. The Nazis had occupied Vitebsk, his hometown, in 1941, and wiped out the 16,000 Jewish inhabitants. Once at Nuremberg, the Soviet prosecution and its eyewitnesses presented a horrific and at times deeply personal picture of Nazi crimes against humanity, including the annihilation of Europe's Jews. The Soviets sent 10 eyewitnesses to testify and ultimately called on 5 of them, along with 2 eyewitnesses sent by the Polish government. These 5 witnesses included people like the head of the Hermitage Museum, Joseph Orbieli, and a Russian Orthodox priest, who were sent to testify about the Nazi destruction of culture. They included the Red Army doctor, Yevgeny Kivelisha, who was sent to testify about the abuse of Soviet prisoners of war. They included a Russian peasant who was sent to testify about the razing of his village in central Russia. And they included the Yiddish poet, Avraham Sutzkever, who was sent to testify about the Nazi campaign to wipe out the Jews. Next slide, please. Sutzkever had been a very late addition to the group of Soviet witnesses. He and his wife, Fredka, had been interned in the Vilna ghetto in September 1941. They escaped 2 years later and joined a group of partisans in the forests of northwestern Belarusia. Before their escape, Sutzkever had smuggled out some of his poems, which reached the Jewish Anti-Fascist Committee in Moscow. And of course, this is Joshua's area of expertise as well. And I learned a great deal from him about Sutzkever and the Jewish Anti-Fascist Committee. The writer Ilya Ehrenberg, a member of this committee, had recognized Sutskever as an ideal witness survivor, and in March 1944, Soviet leaders had airlifted him and his wife out of German-occupied territory to Moscow. And in Moscow, Sutskever worked with the Jewish Anti-Fascist Committee to compile evidence for the Black Book, a massive compilation documenting German atrocities against the Jews in the occupied Soviet Union. Soviet leaders had been contemplating using the Black Book as evidence at Nuremberg. At some point, though, they decided to send Sutskever in person. So let's turn now to Sutskever's testimony, and the next slide, please. So on February 26, Soviet Assistant Prosecutor Lev Smirnov gave a presentation on the Nazi plan to exterminate the Jews. Smirnov introduced shocking documents, including a report from the commanders of Einsatzgruppe A, bragging about having fulfilled orders, and I'll quote here, to eliminate the Jews to the fullest possible extent in Latvia, Lithuania, and Estonia. The following morning, Smirnov brought in evidence from Eastern Europe, including a Polish government report stating that, and I'm quoting again, 3 million Jews have been exterminated in Poland. Smirnov then called Sutskever to testify. Stepping into the witness box, Sutskever was visibly overcome with emotion. His testimony was harrowing. He spoke about the Einsatzgruppen and the systematic killing of the Jews in Vilna. He also recounted the murder of his newborn son by German soldiers in the ghetto hospital. Sutskever was the only witness to remain standing in the witness box, as if, as he later wrote in his diary, it had been a matter of saying Kaddish, the Jewish prayer for the dead. He considered it a matter of Jewish destiny, he wrote, that he, a Yiddish poet, had survived to judge Alfred Rosenberg and Hans Frank in Nuremberg, and through them, all who had adhered to their ideology. Sutskever's testimony played a powerful role for the Soviet prosecution and for the IMT as a whole. It helped the Soviet prosecution to integrate the story of the annihilation of the Jews into a larger narrative about Nazi crimes against humanity in the occupied East. And it also helped to bring meaning to the numbers. Trainin and Sutskever were both critical to the Soviet search for justice at Nuremberg. They both helped the Soviet Union to bear witness to Nazi crimes in different ways. And after Nuremberg, they had different trajectories and different fates. Sutskever got permission from the Soviet government to emigrate to Israel after the war. Trainin remained at Moscow's Institute of Law in the Soviet Union until he fell victim to Stalin's anti-cosmopolitan campaign, along with other Jewish professionals and cultural figures. Trainin's time abroad, his ties to Western lawyers, and his Jewishness became liabilities. Now, Trainin escaped arrest, but he was publicly rebuked as a rootless cosmopolitan and accused of participating in an anti-Soviet conspiracy. And the irony of this could not have been lost on Trainin, who had helped to develop the Soviet idea of a criminal conspiracy in his legal writings. Even as Trainin fell out of favor in the Soviet Union, though, his concept of crimes against peace lived on and helped shape discussions in the United Nations about international law. But Trainin's contribution to the legal framework of the IMT, just like the Soviet role in creating the IMT, and just like the Soviet contribution to the record of the Holocaust, was for a long time forgotten. While Nuremberg shaped the memory of the Second World War, the Cold War, and the anti-cosmopolitan campaign shaped the memory of Nuremberg. And so what I want to argue is that we need to reopen the Nuremberg story. We need to retell the story in all of its complexity, including within it the role of the Soviet Union and the role of people like Trainin and Sutskever. That's the only way to have this fuller picture of the post-war search for justice. This means accepting a level of historical complexity. The Soviet role in the Nuremberg trials was very complicated for reasons we don't have time to get into right now. And the real Nuremberg story, I should say, is incredibly messy. But if Nuremberg is going to offer meaningful lessons, we need that more complicated history. We really need to understand what actually happened. Okay, thank you for your attention. Okay.
Thank you very much, Francine. We have about 18 minutes for a discussion between the speakers and also for Q&A. So just to remind the audience, any questions or comments you want to raise, please use the Q&A function and type it in there, and I will pick it up from there. Now, you probably will have questions and comments to each other, and we should definitely keep some time to have that. I just want to begin with one question to kick this off. One of the protagonists in all of your stories are lawyers, right? Very important players in this, very often Jewish lawyers. So I would like to get your kind of response on the significance of lawyers in this history, and also Soviet lawyers in this case. In Diana's case, very interestingly, Soviet lawyers who are not trained in the Soviet Union, right, and don't behave like Soviet lawyers. And experience, what does what they actually saw during the war, how does that play into the way they interact after with this story? So I don't know who wants to begin.
I may just say a couple of words, because what happened to those particular lawyers during the war, just because, you know, you have a family name in the dossier, you see what kind of appeals or what kind of actions that they do, but you do not have the possibility to have the full biography. But from the Soviet documents, from the Soviet, they do complain about, like, you know, these lawyers, they act apolitically. It was a whole report of analyzing the activity and saying that they basically sending also a complaint to the Collegium of Advocates in Soviet Moldavia, saying you just like discipline them because they act irresponsibly during the trial in court. Actually, when the lawyer managed to get the testimony of the NKVD guardian guy, the authorities were outraged, and they said, like, this should not happen again in the future. Because of this particular appeal, the Supreme Court, the military collegium in Moscow, basically sent all the materials back to Chisinau, said, like, try again, like, start again. So definitely they were standing out in comparison with their Soviet trained colleagues. And I'm assuming, first of all, just because they were not yet accustomed to the type of behavior, I would assume that, you know, in time they would learn the lessons and the rules, especially the number of admonitions. But, you know, very early, 45, 46, they probably didn't even have enough time to learn this lesson. And this is why we also see actually that a lot of Jewish defendants, also interestingly, they make kind of comment. I haven't seen like Soviet citizens making. It's clear that that politicization was not enough for them to understand like what should be said and what shouldn't be said inside the Soviet Union. They'll get there, but they needed some time.
Thank you. Yeah, Francine, do you want
Go ahead, Francine.
Oh, yeah, sure. No, I mean, lawyers are a really important part of my story. And part of the research that I did with the book was really investigate a whole group of these international lawyers in the Soviet Union and thinking about like who they were and their training. And one of the things that was interesting for me was someone like Aaron Chainin. He was kind of on the outs for a while, but that he's brought in part because he has a knowledge of Western European law. Chainin had gotten his education before 1917. Chainin had studied in Berlin. He knew foreign languages. And so I think it's when we talk about Soviet lawyers, also, we're talking about these lawyers in the Soviet Union that were working for Soviet institutions. But for many of them, their educations and their training is much broader than that. and would be very different from the lawyers that were trained the generation after him. And we see then a real difference too between someone like Trainin, who received that education, and members of the Soviet prosecution team who didn't have that deep legal training, who Rudenko got a 2-year certification in law after he was involved in show trials. And so there's that divide as well. At the same time, I just want to say that it's when I first started working on this project, I was very tempted to draw I had a line in my head between like the Trainins and the Rudenkos. But one of the things that I also learned is that Trainin is working for Wyszynski in the 1930s as well. And he's coming up with some of the idea of conspiracy that he comes up with. It's used in the Moscow trials. And so it's tempting to draw these lines, but it's, I think you have to look at each biography individually to really get a sense of each person.
Thank you.
I'll pass. It's okay.
You'll pass? Okay. We have a few questions from the audience already, and it might be good to pull some of those in. And there's two about Lemkin. So there is a question of, that nobody spoke about Lemkin and Lauterbach, I think is one question. And the other is, did the Soviet lawyers know the debates about genocide, Lemkin and so on going on in the West? So to what extent are there exchanges between the sides?
I'm happy to talk. I mean, yeah, but I want to give someone else to Joshua or Diana.
Oh, go ahead.
Yeah. So no, this is, so Trainin he's very well aware of, even before, so the discussions about genocide are happening in Nuremberg, kind of behind closed doors. Lemkin is there. He's trying to get the concept of genocide to be used more. It makes it into the indictment as a war crime, actually, but then it's not brought up again in the trial until later. And the Soviets are very well aware of it. And they're not concerned about it, because the Nuremberg trials, it's just trying the crimes of the European Axis powers. That's very clear about that in the Nuremberg Charter. The Soviets become more concerned about this concept of genocide and other international law ideas being used against them later, when there's talk of expanding the Nuremberg principles. And so, and I would also say that the Trainin, even in his writings in the 1930s, he's engaged, he's in an exchange with Lemkin in particular about ideas of barbarism, about Lemkin's critique of communism. So they're part of that larger world. And Lauterbach, his influence, of course, is on the formation of the idea of crimes against humanity. And that's another critical piece of the story.
Mm-hmm.
Maybe I can say a couple of words, although it's like my lawyers, they were definitely not, I don't know if they were aware of this discussion, but they were not speaking in this kind of terms in the dossiers that I've seen. But nevertheless, they were very much promoting a discussion about their defendants being victims. So they're pushing for the court to see them as victims, not as perpetrators, but like emphasizing each and every time, their appeals and their argumentation in court, that these are the people who were also like slaves, who were and saying like "Они работали из-под палки." They had no choice, and really making sure that they are not like collaborators in the classical sense of what the Soviet court would understand, but they are a different category of people, and they are victims. Although they also like victimizing others, but they had no choice. They were basically under duress. So in this sense, they were very active and like making clear and like introducing this discussion in documentation.
Josh, we have a question about the Black Book, which is whether or not Aaron Trainin was involved in it.
To my knowledge, he was not directly involved in it. The Black Book was initiated by Ilya Ehrenberg in the context of the Jewish Anti-Fascist Committee. Vasily Grossman joined him, and then Ehrenberg left the Literary Commission in protest to how the Anti-Fascist Committee and Soviet authorities were using material from the Black Book. Grossman played some role in finishing the editing, but Ehrenberg never really divorced himself from it. He did what he could to preserve the material. until well past Stalin's death. It was Ehrenberg's daughter who also helped preserve the material after Ehrenberg's death and arranged for much of the material to be delivered to Yad Vashem years later. So this was a project by journalists, by about 24 journalists that Ehrenberg organized during the war itself, while the catastrophe was still unfolding. And some of his closest friends were involved in it, including Avadi Savich, whose wife, Alla Savich, was the daughter of the last chief rabbi of Moscow, Jacob Mazeh. There's a street in Tel Aviv, Rehov Mazeh, named for her father. She was among Ehrenberg's closest friends. And so it was very much an expression of their loyalty to their fellow Jews and their defiance both to the Germans and to Soviet anti-Semitism, is how to understand the Black Book Project.
Thank you. We have some more questions, but I want to, before we go to some of them, I would like to give each of you a chance to ask each other questions or give commentary on your papers if you wish.
I'll ask Francine quickly. So much has been written about Nuremberg and the idea that at the International Military Tribunal, the main issue was peace and aggressive war. But in fact, the Holocaust, as we know it now, was mentioned many times with witnesses and documents. Would you just speak to that?
No, absolutely. That's part of this kind of false notion that the Holocaust wasn't talked about. And I think that just if one reads through even the transcript of the evidence that was introduced, and if one reads through the witness testimony, it's a huge part of the American case. It's a part of the French case. It's less in the British case, a bit less, but and then it's important to the Soviet case as well. And so again, the thing about the Nuremberg trials and the importance of crimes against peace is that crimes against humanity as a charge and in the judgment, it became restricted. And so Nazi crimes, so German crimes against the German population before the start of the war were not prosecuted. And so there's a difference between the record that we have as a result of the Nuremberg trials, the record that we have because of the testimony, because of the evidence, and there's just, it's an overwhelming amount of evidence about the Holocaust. But in the end, what the judges took into consideration, that was limited to crimes against humanity that were carried out in connection with the aggressive war. So,
are there other?
Yeah. I wish we had more time because I found both of your papers to be just so thought-provoking in terms of this question of collaboration and questions of morality and just, it was so striking to me hearing the papers one after the other with, on the one hand, it's a question of agency, right? And the Jews who are then put on trial in Romania, but then the Germans who are let off as a result of American concerns. And I don't know, it's not so much a question, I guess, but it's more of like an observation. And I guess the question is, like, how do we make sense of this? Like, this, and again, if there's just these different ideas, these different political systems and different ideas of justice, like, how do you make sense of each other's stories? To Joshua and Diana.
Go ahead, Diana.
To make sense of it, I think like it's kind of about like different political systems, and those like political systems came with different understanding of what is the sense and the role of a legal system, in addition just like to distribute justice, but then it's also the role in society of like what the state wants to project. You know, there's like so many other, especially in a state like Soviet Union, so many other political goals are involved. So in this sense, like Soviet system is very different from like Western system. And then like Cold War, I am amazed like how actually very little like discussion is about the impact of Cold War on the post-war justice. And this actually, it's like does a lot of unfair the historical knowledge and understanding, because like a lot of war criminals like rode this wave of Cold War successfully and managed to avoid punishment because they could do it in the context of a raging Cold War.
Very
Let me
strong.
just point out one thing, that in Germany, after World War II, when we had all these death sentences imposed on defendants at Nuremberg, the Germans threw back at the Americans Abraham Lincoln's appeal to the South after the defeat of the South in our Civil War. And they said, well, remember what Lincoln said to the South, with malice towards none, with charity for all. That should be your approach to Nazi war criminals.
Yeah, and I mean, this Cold War giving people a way out is very strong in my adopted country, Australia, which admitted quite a few fugitives, right, from communism who turned out to be war criminals. There's a very powerful book by Mark Arons called War Criminals, which is charting this kind of post-war erasure of the memory of what actually in the immediate post-war years was there, and then gets sort of forgotten. We have about just under 2 minutes, and I see that Michael came back in.
I did.
Michael, can we take one more very short question?
We can do 1 more minute of commentary.
Okay, I have for Josh a question, which is about the New York Times misreporting the numbers as hundreds. Was that because of ignorance, or because they just couldn't imagine the scale of the murder, or was that deliberate misreporting?
I do not believe ignorance is quite the right word, and I don't think it was deliberate misreporting either. I think in my book, I used the phrase moral amnesia. Of course they knew it. They covered Nuremberg. They knew who Ben Ferenz was. He was a lawyer in New York at that point. There was a great deal of commentary when the Nazis were granted clemency in the early 50s. There were objections from Eleanor Roosevelt. The New York Times editorialized against it. But by 1958, all of that was kind of forgotten. And the article was actually a very modest article. It's not on the front page or page 2. It's deep inside the front section and very brief.
I would like to thank our distinguished panel. It really was a pleasure to listen to you all have a conversation today. Thank you so much, Mark, for moderating. Thank you to Francine and Diana and Joshua for your participation. Ladies and gentlemen, we are going to conclude this panel and enter into our next program. Thank you so much.
Thank you.
Thank you. Bye.
Right.
Bye.